Hi brokers, I'm Cassandra Gaines. This video is to help you when you receive a shipper carrier contract and you're a broker. You don't have carrier authority. We all know in our industry you're not supposed to sign an agreement holding yourself out as a carrier. It's some of the highest risks in our industry. So this video will give you some tips and tricks. First, it seems obvious, but train your salespeople on what to do when they receive a shipper carrier agreement. For example, try not to have a contract at all with the customer. If that doesn't work, ask the customer how normally internally they handle these agreements when brokers want to make edits and when other brokers have addressed the issue of, hey, we're not a carrier, we're a broker. If the customer comes back and says that no edits are allowed, do you forego the business? I would tell you to have an analysis already in place and teach your salespeople to do the same. They should come to you as a leader with the estimated business, the lanes, the commodity, the value, anticipated value of the goods, if possible. And you guys should have a holistic conversation on whether you want to accept the risk of signing a broker-carrier contract and holding yourself out as a carrier. Some brokers decide that if the income, the potential revenue, is high enough, the risk is worth taking on. If that's the case, I then develop procedures. I've worked in-house for numerous brokers, and I have also been outside counsel for numerous brokers. I love procedures, and the reason why is because if you're moving fast and you're growing fast, procedures keep you from losing money. Develop procedures. If you sign a shipper-carrier contract holding yourself out as a carrier, make sure you put a reminder in your calendar to check on the volume of this business to see if the revenue has made the risk worthwhile. Sometimes we sign these contracts and then 6 months to 8 months pass and we really haven't received much volume. That is a different analysis. You may decide that you don't want to take any shipments at all because the risk is not worth the revenue you're receiving. Also, another internal procedure. Make sure that no one is signing these agreements except for the appropriate folks. Have an escalation policy. That way you're not surprised later on when the agreement has been signed and no one had that holistic conversation that everybody needs to have about these agreements. The reason why is often these agreements require you to be the carrier and be responsible for any and all loss. You're risking your business, you're risking your insurance, and you're risking your authority as well. The other thing, I am a compliance guru. I love compliance, carrier compliance. I love vetting carriers. I think it's an art. I don't think it's something you delegate and you just leave to an electronic platform such as RMIS. I think it's something you supplement it with. So when you have a contract that you've signed as a shipper carrier contract and the shipments are risky, your business transaction is risky, you should use carriers that are good business partners. What that means in my mind, and it might mean different things in yours, is that these carriers have run certain amount of loads with your company. You understand their business and you know them because you've had cargo claims with them and they pay quickly. You don't have a lot of issues. You don't have hostage loads. So you feel comfortable with those carriers and you feel that from a broker's perspective, they are good business partners to have on high-risk customer accounts, such as one that you signed a shipper-carrier contract with. I like to make sure that I flag in the software as possible or my compliance team knows and understands what customers and what shipments are high risk and should be with business partners versus brand new carriers or putting things on load boards. The other tip is, and this one's often overlooked, and when I'm in-house or when they're my clients, I train people over and over about this. When you are contracting with a customer, make sure you ask what the commodity and the value is. Make sure to research online. Make sure to get as much business information as possible. We all know shippers often will not tell us the information, so we have to do our own research. But you should get as much information as possible because you may find out that these shipments are overvalued over $100,000, or they're a hot commodity. So there's something like an energy drink that's often stolen in Texas, and the lanes you are contracting for are running right through Texas. So make sure you fully understand the commodity, and the customer before you contract and decide to sign on a shipper carrier contract. My last tip is an obvious one, which I'm sure a lot of you do, but make sure you're checking with your insurance brokerage and you're understanding your coverage. Because if you have coverage, if you have an auto liability policy that does give you coverage for the risks that you have just signed on, there may be a lawsuit or something that happens that goes beyond the coverage that you have, which would shut your business down. So as you can tell, I'm big on risk management. I don't like to pass up business opportunities. I think you can have procedures and be strategic about how you approach these types of contracts. But I think you need to be aware, track these contracts, and have appropriate procedures and calendar reminders. That's how you avoid being surprised 2 years from now when your business is doing really, really well, and all of a sudden you're getting hit left and right with claims and lawsuits and whatnot because you were signing contracts 2 years ago and not keeping track of this stuff. This is Cassandra Gaines. I love this stuff. I'm a logistics attorney. It's what I specialize in. It's what I live and breathe in. Call me if you need anything or email me or message me.